dated on the 13th.
All right, Mr. Richards, good afternoon. I'm going to follow up on some points that council has made with you. I'm begin by, Your Honor, addressing my motion on redirect. And that is, I'll ask that Exhibit 283 be pulled up, Hunter, if you can. And you could go to page 283-023. And Mr. Richards, you were read, or council had you read a paragraph of your report. It's actually that last paragraph there, the sub-basin creation. You recall that? Or the sub-basin created by Order 1309. You see that paragraph?
Yes.
You recall being asked questions about that paragraph?
Yes.
And you have an entire section, don't you, on Order 1309 in your report?
Yes.
Not all those sections, not all those paragraphs were shown to you by council, were they?
They were not.
All right. If you could page through, Hunter, page 23, page 24, and then we'll go to page 25 up to the 2023 pamphlet. Your Honor, I would ask that this section of the report be included. I'll have another section of the report to be included as well as an exhibit in this case, so that Mr. Richards' testimony can be fully contextualized and completed. I cited to you NRS 47.120 subsection 1, as well as Coleman versus State, for the proposition that when a portion of an expert's report is introduced into a trial, that the court can then admit remaining portions of the trial, or excuse me, of the expert report, or even the entire expert report, actually, as was done in Coleman versus State, for purposes of completeness and fairness in rounding out the expert's testimony and what he said in his report. So I would ask that occur. On the other hand, I guess I could just simply read it in the record. It seems to me.
Pose questions about it.
That's the point, right?
You can pose questions about it.
Sure. Okay.
I would have to take it down. He can certainly have the.
I'm gonna ask him questions about every one of these paragraphs.
Okay.
Great, but he has the report in front of him, so he can ask the questions without having it displayed on the screen.
Okay. Your Honor, can I have it on the screen for purposes of my benefit, or is that not allowed?
Do you have it in front of you?
I got it on the screen. I got it in front of me.
Just look at what you
Witnesses got it in front of them.
I just look at what you got.
Okay. Mr. Richards, take a look at your report, page 23 of your report. Did you got it there?
Yes.
All right. You take a look at that first paragraph under Order 1309, and then you have three parts of the order in relevant parts that you set forth in your report. Do you see that?
That portion of my report is on page 22.
On page 22. Oh, I'm sorry. All right. Maybe I misnumbered these then. All right. Do you see though the portion that council read to you that at the very bottom?
Yes.
Okay. So I want to have you address the portions at the top. Okay.
Okay.
All right. So in preparing your report, you had this paragraph and you had relevant portions of the Order 1309 set forth before the paragraph that council asked you about. Can you explain to the court what portions of that paragraph and those portions of the order related to the paragraph that council read to you? Please make your report complete. And if you need to take your time to just read through it, please do.
Can you repeat the question again, please?
Sure. As it relates to the paragraph that council had you read previously, in order to complete your testimony and your opinions in this case, what would you like to include in the paragraphs that preceded the paragraph that council read to you?
Well, it included Order 1309, restricted the amount of groundwater pumping within the super basin without taking into account how groundwater pumping in each individual hydrographic basin may affect the muddy river flows, no matter how far away the individual basins are from the river, and no matter how close the wells in the Muddy River Springs area basin may be to the Muddy River.
And why was that portion of your report important to your opinions concerning Order 1309?
It was important because a conflict determination has not been made. And when I say a determination of conflict has not been made, and I mean that with respect to not just Coyote Springs water rights, but with respect to all the other appropriative water rights that are now consolidated into the super basin. And in my opinion, that matters because I made 4 opinions in this report, including the opinion that 1309 effectively took CSI's water rights after they had been lowered in priority by 1309 and gave those rights to other water users ahead of CSI. And that was done without having, without a determination that CSI, the use of CSI's water rights would conflict with any water rights. So, and it seems to me that the inequities in this matter have been made more egregious because not only were CSI's rights taken away and given to other water users, that was done without a determination of conflict.
Mr. Richards, what would be required to determine a conflict actually existed?
With respect to CSI's water rights?
CSI's water rights, you were asked questions about that focused on the point that CSI's use of its water rights can't conflict with decreed rights on the Muddy River or couldn't conflict with the Wapadees. You also asked questions about further regulation, the state engineer reserving further regulations, and you said, if a conflict is found. And you just referenced in your report this idea about a conflict not being found, and yet CSI's rights being given, the use of those rights being given to others. What would have to happen in order for the state engineer to determine that a conflict actually existed between CSI and either the Muddy River decree rights or CSI's rights and the Wapadees?
Stretching foundation?
Overruled.
You can proceed.
Well, I think in order to make a specific determination that CSI's water rights or the use of CSI's water rights create or create a conflict with vested decree rights in the Muddy River system or the public interest in protecting the Moapa days. I think a very specific and controlled test would have to be performed on the individual wells that CSI has permitted rights to pump water from. Not all of the wells in the Coyote Springs Basin, not all the wells in the entire super basin, not even all 4 wells of Coyote Springs wells at the same time. I think a very specific test would have to be conducted on the individual wells. It would have to be a controlled test, and there would have to be persuasive interpretation of the data and results of that pump test in order to draw a conclusion that pumping from any one of CSI's specific wells had any measurable impact on the spring flow or the flow of the Muddy River. That might look something similar to the very specific pump tests that were conducted in, I think it was 92 and 93, as cited in ruling 4542, as described in ruling 4542. That ruling described very specific pump tests that were conducted on a single well, and the results were the results of that pump test were assessed to determine what the impact of that pumping well had on the headwater springs in the Muddy River and the Muddy River itself. And as I mentioned in my cross-examination yesterday, ruling 4542 actually describes 2 pump tests. One pump test was conducted on, I think it's called the Arrow Canyon well, which is in the Muddy River Springs Basin. That well was pumped under a controlled system, and the effects that pumping well had on the headwater springs of the Muddy River and the Muddy River itself were analyzed, and the state engineer made a determination, as it's described in detail in ruling 4542, that as a result of that pump test, there was very little measurable impact on the Muddy River Springs and the Muddy River from the pumping of that Arrowhead well. And similarly, ruling 4542 describes a second pump test, similar, very controlled pump test on a specific well that was located, I think it was described in ruling 4542 as being located very close to the proposed point of diversion or the proposed well that was associated with permit 46777. And the results of that very specific, very controlled pump test, results of that pump test were also described in ruling 4542. And the results were the same, very similar. and the state engineer describes the details of those results. I don't want my testimony here to mischaracterize it in any way because I don't have it in front of me. But basically, I think the state engineer concluded that, again, there was no measurable impact on the Muddy River Springs or the Muddy River as a result of the pump test that was conducted on that well in the Coyote Springs Valley, conducted in order to, assess if conflict is occurring. There's potentially other ways, but that's what comes to mind first.
And counsel, I did want to make a point. I believe that Mr. Sylvester did read from the report in posing some of his questions.
Yes, sir.
When I told you that you couldn't put it on the screen, I didn't mean to say that you couldn't read.
Mr. Richards, based on we know that ruling 4542, at least the time frame for that ruling was from 1983 to 1997, because that's when the application went in and that's when the ruling came out. We've talked about that before. Right?
Objection mischaracterizes this, the document itself, Your Honor. Had nothing to do with that period of time. It was a 121-day pump test.
Your Honor, counsel, you didn't hear my question. It wasn't anything about a pump test. So, okay. So we're talking about a 14-year period from the time of the application submitted until the ruling came out in 1997. Roughly that kind of time frame, right?
Yes.
So you described a couple of very specific focused pump tests that were referenced in 4542. My question for you is, other than those pump tests referenced in 4542, after having reviewed everything that you reviewed in order to formulate your opinions and you've set forth in your report and your testimony, are you aware of the state engineer conducting that kind of a specific targeted pumping test in Coyote Springs to determine whether or not there's an actual conflict with the pumping of water in Coyote Springs and the decreed rights or the Moapa Days issues in the Muddy River area?
No.
Is it significant to you, in your expert opinion, that CSI has been deprived of its ability to use its water rights for their intended purpose of developing the Coyote Springs community without the determination of a conflict?
Objection
Yes.
Foundation?
Ruled.
Yes, it is significant.
Please explain why that's significant to your opinion or opinions.
Well, it's significant for many reasons, but just generally, their Coyote Springs rights to use water have been blocked, and there is without a determination or quantification that some conflict has occurred. It just seems inequitable. Seems you would need to have a basis other than what's essentially a presumption of a potential conflict at some point in the future to halt or block their ability to use their water rights that were granted back in 1997.
Thank you. I wanted to have Exhibit 556 shown. We introduced this through you as a new exhibit. 556. You've got the. It's actually page 24 of Exhibit 283. We just made it a separate exhibit. So if you just probably easier to pull up 283. Yeah, there you go. This was in the section of your report, order 3909, or excuse me, order number 1309. The paragraph that I had referenced, or the section where the paragraph that I had referenced, counsel had read to you, then you had read some of the parts of your report before that paragraph that was read to you, and you just commented about that in your last few minutes of testimony. Now, what I'd like to do is stay within that section of your report. And after this exhibit, which is now exhibit 5556, you say this in your report. And that water rights that were originally granted for use in 3 basins other than Coyote Springs Basin. You see where I'm on in your report?
Can you direct me to which page you're on, please?
Go to page 24. It's actually 23 of your report, but it's base number 024.
Okay, I'm
You
here.
there?
Thank you.
All right. You see your table there?
Yes.
That's where I'm at.
Okay.
You wrote in your report, as shown in table 3 above, water rights that were originally granted for use in 3 basins other than the Coyote Springs Valley Basin were merged together as part of the super basin. And the priority dates for the water rights in those other 3 basins, Muddy River Springs area, Garnett Valley, and California Wash, pushed CSI's 1983 water right permit number 7095 to the bottom of the list in terms of the 8,000 acre foot limitation on water use within the super basin. You had commented about that previously when we were talking about this exhibit. Is that correct?
Yes.
And is there anything else in that paragraph that you think is important in terms of making sure that we understand what your exhibit is seeking to show as table 3 in your report?
Well, what's not included in that sentence is that as a result of pushing Coyote Springs water rights to the bottom of the priority table, to the bottom of the 8,000 acre foot pumping cap, CSI's other water rights, which are not on this table, are outside of the pumping cap. They were effectively given to the Muddy River Springs area, the Garnett Valley permits, and the California Wash permit identified in this table.
Thank you. If you could turn then I want to just direct your attention to one more paragraph in this section. It was not read on cross. Let me take you to the last paragraph of this section. And it's still referring to table 3, still referring to what we've marked as exhibit now, or actually had admitted as exhibit 556. And you state here in your report, as shown on table 3, creation of the super basin gave priority use of water ahead of CSI to 48 permits in the Muddy Springs area, 8 permits in the Garnett Valley, and 1 permit holder in the California Wash Basin. Referring to map 3 in attachment B, the majority of Garnett Valley is located more than 10 miles south of Coyote Springs Valley and separated by Hidden Valley. Why is that a significant fact in terms of what you're trying to describe here and your opinions related to Order 1309?
Well, I think I touched on this yesterday. The perennial yield for the Garnett Valley, hydrographic basin, was 400 acre feet annually prior to the creation of the super basin. And so the water right permit holders in Garnett Valley prior to the creation of the super basin were had a very small, relatively small perennial yield amount that was relevant to how much water could be diverted or pumped from that valley without exceeding the perennial yield. And the Garnet Valley permit holders in this table, for example, are moved up in the relative ranking of priority relative to the Coyote Springs Valley permit is 74095, and all other the Coyote Spring Valley permits that didn't even make it into this table. And so there's a benefit an inequity, in my opinion, that was created by ruling 1309 as it's exemplified here in this table, because not only do these Garnet Valley permits exceed the 400 acre foot perennial yield of the original hydrographic basin, they're now only restricted by the 8,000 acre foot pumping cap. So Coyote Spring and their water rights, on the other hand, were granted the right to use 5,000 acre feet, 4140 acre feet after some sales. But the Coyote Springs Valley permits, which were originally granted on the individual basin by basin administrative scheme, they were granted in a hydrographic basin that had 18,000 acre feet perennial yield. So there's just the inequities are compounded here, in my opinion.
All right, Mr. Richards, let's turn to another section of your report that council had referenced. It's the 2023 pamphlet. And if you'll turn the page, I think this is on page 26, the base number is 026 of your report. And just get to the, you can see that on page 25 of the report, it's the 2023 pamphlet that you had some time with counsel on in cross-examination. The last paragraph of that section of your report was read to you. That part was, none of the orders and rulings that are attached to the pamphlet merge multiple individual basins into a single hydrographic basin, as Order 1309 did when it created the super basin, and then restrict or curtail pumping in a newly created subbasin based on the relative priority of water rights and a newly created super basin, as Order 1309 did. So you were questioned about that. The continuation of that paragraph states, quote, "The orders and rulings attached to the pamphlet do not make reference to more than one hydrographic basin, and the perennial yields is more than one, and the perennial yields in more than one basin. However, the orders and rulings in the pamphlet do not merge hydrographic basins to create a single hydrographic basin, merge the water rights from the individual basins, and then restrict groundwater pumping to an amount that is lower than the sum total of the individual basins' perennial yields, with reprioritization of each water right in relation to the others in the newly created super basin, as Order 1309 did." How is this part of your report significant to your opinions about the uniqueness or the, as you've said, unprecedented nature of ruling or Order 1309?
Order 1309 is just that. It was unprecedented. And to elaborate on that, I've heard this notion reference made to foreseeability and the notion that CSI was noticed and should have known or could have known. In my opinion, the notion of foreseeability is incompatible and inconsistent with the precedent-setting creation of the super basin. And furthermore, and I said this in my rebuttal report of Mr. Sullivan, but which we didn't discuss, but in my opinion, nobody could have predicted, and really it's not a question of foreseeability. It's a question of being able to predict something. Nobody could have predicted that the super basin would be created. Nobody could have predicted that there would be that the long-standing basin by basin approach would be replaced in this instance with the creation of a super basin, and all the perennial yields of that historical basin by basin approach would be erased and replaced by this 8,000 acre foot pumping cap. Nobody could have predicted that. I adamantly disagree that it was foreseeable. And I base that opinion in large part on the fact that it took a decision of the district court to make an initial findings of fact that the state engineer even had the authority to do that. And nobody could have predicted that the Supreme Court would have the district court
Objection, Foundation, Your Honor.
reevaluate
Overruled. We can stay this.
the original findings of fact. And nobody could have predicted, and certainly not in 1997, that in May of 2025, a district court would make a determination that the state engineer did in fact have the authority to do this, to create the super basin, to change the long-standing practice of how water rights were administered. And nobody could have predicted that the state engineer would also have the authority to erase the individual perennial yields and create a pumping cap on this unprecedented super basin.
Thank you, Mr. Richards. Let's just stay with discussion about the Nevada Supreme Court and the Sullivan decision. Council had questioned you about that. And if we could pull up Hunter 3822. This is the Sullivan opinion that, and I'm just going to spend just a moment with you on this. Council spent some time with you on this, and go to the, and I'm not even sure what page this is on. It's the 26th head note. See if you can find that. One more, is that 26? Do you have that down, Kevin, what that is?
Yeah, it's page 15.
Page what, 15? 0015, please. Right there. Pull that up. I'm not going to reread this. Councilor read this to you, but I'm just going to note, let's just get kind of right to the note of it. Go down about 3 sentences where it says no deprivation See, see what's no, it's just that sentence. Yeah, just highlight that sentence. Magnify and highlight. Okay, you asked questions about this. Mr. Richards, in cross-examination, correct?
Yes,
That the Nevada Supreme Court said no deprivations of priority property rights occurred because order 1309. You said in the portion of the interim order 1303 that we reordered priority rights, and you testified about your view on that. And I'm not going to have you replow that ground, but I do want you to just answer this question. Even assuming that's correct, even accepting what the Supreme Court said, which you said you did, even accepting what the Supreme Court said, do you believe that there was a practical effect in order 1309, which in fact reordered priority and created junior rights out of senior rights for CSI?
yes, I do. And I stated that, I think.
And
previously.
just so we're crystal clear on this. Why is that?
Ask and answer, Your Honor. Overruled.
As I stated in direct, 1309 did not rescind the doctrine of prior appropriation. 1309 did not change the priority dates of any water rights now contained in the Super Basin. 1309 did not create a management plan. 1309 did not change the Nevada State Engineer statutory requirements to administer, control the relative rights and in accordance with priority. And therefore, in my mind, the prior appropriation doctrine still controls.
Mr. Can you pull up, please, for us, Hunter, exhibit 210? Your question about this document, I'm not gonna have you take a look at anything in particular. But even if Order 1309 rescinded Order 1303's reprioritization provision, does this exhibit 210 still show the relative priority and seniority rights of CSI's water rights today?
Yes,
Why?
because this is a tabulation of all the permits in the Super Basin, except for Cane Springs. And this tabulation was created by the state, and it's ranked according to the order of priority date. And you can see that Coyote Springs water rights don't even appear on the first page of this table. I don't know how many rows there are, but it's probably 40 or 50.
Next one, Hunter. There, right? Of course, we know that's where it's at. That's where the water rights are. All right. Next question. Hunter, if you can pull up exhibit 283-024 again, that's that exhibit 252, I'm sorry, 556, new exhibit 556. That's the one right there. Pull that up again. Mr. Richards, even if Order 1309 rescinded the reprioritization provision of Order 1303, is this exhibit still accurate?
Yes,
Why?
for the same reason I stated the prior table was accurate. It's the same data that we just discussed in the prior table. It's in the larger expanded priority table. This is just a consolidation of the same data.
Yes. All right. Next subject. Council had you take a look at your deposition. Have you still got your deposition in front of you?
Yes.
All right. I'd like to have you turn, if you would, please, to page 105 of that deposition. I'm going to read to you the question and the answers that counsel had you read in response to one of your questions. This is for the record, page 105, starting at line 10, and I'll continue on through page 106 to line 3. Question: and if the applicants go forward and attempts to establish beneficial use like drilling a well or installing this infrastructure, and it's ultimately determined at the end of that process there's no water available for appropriation and development, is the state engineer required to reimburse or return those funds expended by the applicant in attempting to develop? Then object. The witness, the state engineer, is not required to return the cost. Question: is it required to reimburse the applicant for the cost expended? And you responded, it's case specific. But I think I would say in general, no. What did you mean by it's case specific?
I meant that I couldn't answer the question definitively, yes or no, because the conditions and details regarding the hypothetical, essentially there was a hypothetical that was asked of me, but the details and the conditions, they would all be case specific. And so there may be cases where the reimbursement would be required.
Mr. Richards, when we started your direct examination, you talked about your experience and your education and your training. When counsel that cross-examined you, he questioned you and asked you about your experience and your training and your education and your qualifications as an expert. And you testified that you've been formally qualified or designated as an expert witness by the state engineer as a water rights and a surface water hydrology expert. You recall that?
Yes.
And that was something that happened on one occasion when you were formally designated and then qualified as an expert, correct?
Yes,
right.
I think qualifications only required one time.
Okay. But then you've also said you testified though 80 to 100 times.
Yes.
Before the state engineer.
Yes.
And when you were testifying before the state engineer, were you relying on your expertise as you've recounted it for the court here today?
I was relying on expertise. Yes.
Were you relying upon your education,
Yes.
your training,
Yes.
your experiences,
Yes.
your professional opinions and views?
Yes.
You were asked some questions as well on cross-examination when you were asked questions about Order 1309, whether there was anything in Order 1309 that precluded stakeholders from coming to the state engineer and submitting evidence or support that they could pump their water without actually having an effect on the Muddy River Decree rights or the Wapadees. You recall that?
Yes.
I think you may have already in part touched upon this, but from a practical standpoint, what would be required for a stakeholder in the lower Right River flow system to come forward with evidence to the state engineer to show him that our pumping had no impact on the Muddy River Decree rights or on the Wapadees?
I think I already answered that question earlier. I don't know that I could add any more detail to it.
You want to just incorporate it?
Yes, please.
Okay. And that had to do with the focused and targeted pumping, is that right?
Yes, sir.
Okay. You were questioned today and yesterday about the water right holders in the super basin, or maybe the permit the permittees, I guess, and other water right holders in the super basin sharing the same source and supply. You call those questions?
Yes.
Would your answer depend on what time frame we're talking about?
My answer with regard to the source and supply,
Yes.
yes,
Why would it depend on what time frame we're talking about, or the question was posed to present?
because the relevant time frame, in my opinion, is May of 2025, when Judge Yeager's amended findings of fact were issued. Prior to May of 2025, the historical basin by basin designation was in place. And prior to May of 2025, the state engineer's authority to create a super basin, to merge everybody's water rights together that were historically in individual hydrographic basins. It wasn't until May of 2025 when that authority and the results of 1309 were actually confirmed to be legal. And so question with regard to source and supply, particularly as those questions relate to this unprecedented and newly created super basin, the answers to that and the relevance of those questions really depend on whether we're talking about pre-May 2025 or post-May 2025.
Thank you. Mr. Richards, you recall a hypothetical question that council attempted to present regarding Pete Morris protesting an application in Basin 215?
Yes.
Did you intend your answers to that hypothetical to alter or change your opinion regarding the historical management of groundwater by the state engineer basin by basin?
No.
Counsel for the state also asked you a question about whether it's possible one of the purposes of ruling 442's monitoring requirement was to watch for impacts to senior rights in Basin 210, the Muddy River Valley area. He asked if it was about decreed rights and statutory rights. Is it both?
I'm sorry, can you repeat that question?
Council asked you questions about the monitoring requirements of ruling 4542. Recall just generally those kind of questions.
Yes.
Okay. And he asked if one of the purposes of those monitoring requirements was to be mindful of or watch out for the impacts to senior rights in Basin 219, the Muddy Springs area. Okay.
I don't remember exactly what his question was, but I do recall some questions of that nature.
Let me just state it for you then. The monitoring requirements in ruling 4542, were those requirements intended to evaluate the impacts to statutory rights and decreed rights, or simply decreed rights?
I think they were intended to monitor potential impacts to the vested Muddy Decree water rights and not statutory water rights.
Now, again, getting back to Order 1309, in your review of Order 1309, I think you may have mentioned this in some of your, maybe one of your answers to cross-examination or question about it in cross-examination. Did Order 1309 present or have a groundwater management plan?
It did not create a management plan of any kind.
Okay. And did the fact that there was not a groundwater management plan within Order 1309 have an impact or effect on any of your opinions?
Yes.
How so?
Absent the groundwater management plan, the prior appropriation doctrine still controls how the state engineer is required to regulate and control water rights within the super basin. And frankly, if and when a management plan is ever created, I don't see how it could not include a priority as part of it. And
What do you mean by that priority?
well, I don't see how a management plan could be created for the super basin without giving recognition to the prior appropriation doctrine and without considering the priority dates of all the water right holders who are now consolidated within the super basin. And I don't see how it can allow pumping from within that super basin or restricting pumping within that super basin on an individual permit basis without giving consideration to priority.
And Mr. Richards, in your experience, who has the statutory tools to resolve conflicts among stakeholders in the lower right river flow system?
Who has the statutory tools? I'm not sure I understand that question.
Sure. Well, one of the questions that was presented to you, or maybe a series of questions, was this idea that in trying to develop a management plan, the state engineer wants the stakeholders to get together and talk about maybe some sort of a consent or some sort of an agreed upon approach because they have conflicts with each other. Just really kind of a follow-up to that line of questioning. Who has statutory tools to address these types of conflicts among the stakeholders?
Objection, you can be hypothetical, vague as to time.
Overruled.
Well, I don't know if I would describe them as statutory tools necessarily.
Okay, how would you describe it?
Well, I think the state has the ability. I think the state has tools, so to speak, and to make a determination of conflict. I think this phase 2 management plan, I think the matters that this phase 2 management plan are intended to address could have and should have been addressed at least concurrently with this development or the development of a concept of consolidating individual basins into a super basin. State engineer makes determinations of conflict. There's hundreds of rulings and many, if not all, of the individual basins in the state. And the state engineer is very commonly made determinations of conflict within individual basins under the basin by basin management scheme and denied applications to appropriate based on their tools to determine if a conflict exists. And so, this phase two process has started. I agree with Mr. Sylvester on that. I know that there was a public workshop or hearing or maybe both. I think it was in February of this year. And the PowerPoint presentation, I didn't participate in that workshop, or that wasn't present at the hearing or the workshop, but I did obtain a copy of the PowerPoint presentation that the state prepared for that workshop. And to be frank, it's very disappointing that the state, despite having the tools to make the conflict determination itself, is, and I appreciate getting the public involved. Don't get me wrong, but it's disappointing, to say the least, that the state doesn't have a plan and is suggesting potential ways to manage the super basin in the future, and then just asking essentially anybody in the general public who wants to participate in these meetings. Any other thoughts? I mean, if I were a permit holder in the super basin and this was the way the process is going to proceed, and I had rights to pump water, but they're not within that 8,000 acre foot pumping cap, I would be offended. I would be offended by the lack of a plan and the approach that's being taken.
Thank you. I'd like to just turn your attention to the last subject that you were questioned about in your cross, and that's ruling 4542. And just to start us off, just a little follow up on two concepts that were addressed by counsel in cross-examination. He talked to you about the public trust doctrine and the anti-speculation doctrine. Does that ring a bell?
Yes.
Okay. In your experience, were those doctrines part of the consideration that the state engineer would have taken into account when evaluating and ultimately approving application 46777?
Yes.
Okay. Let me turn with you to that ruling. That's Exhibit 99. Just for the court's notes, that's also State's Exhibit 3078. So Exhibit 99 and State's Exhibit 3078. Counsel asked you questions about whether you had reviewed some of the studies that were cited in ruling 4542, and he referenced a couple of different reports there. Let's just turn to those and remind ourselves. This is going to be Hunter Exhibit 99, page 3. And we'll just take a look at, and we'll look at footnote 3 there. Or sorry, footnote 4. So you see that you got the Eakin report that counsel referred you to. That's the night. If you go all the way at the bottom of the footnote, to the end of the footnote, I guess you'd say, that's the 64 report. And then Hunter, let's turn the page over to page 4 of Exhibit 99, footnote 8. You'll see that's another Eakin report. That's the 66 report that counsel referenced. And then if you turn to page 5, footnotes 9 and 10, once again, there's a reference in 9 to the Eakin report. That's the 64 report. And then there's also the Rush report in footnote 10. And in in response to council's question, you said that you had reviewed some, I think, summaries and abstracts, and council characterized that as kind of a cursory review, maybe suggesting that that you were not as thorough as you could have been. Do you believe that you reviewed and evaluated ruling 4542 sufficiently to support your opinions?
Yes.
All right. Would you believe, based on what we just looked at in the footnotes and you having read ruling 4542, that the state engineer read and even studied and considered the Eakin reports, the Rush reports, and the other sources set forth in ruling 4542?
I assume they must have. Or
They're
the
cited,
the
right?
state engineer must have.
They're, I
Yes.
mean, they're cited, right? In
They're
state
cited.
engineers, in then state engineers ruling. So, Mr. Richards, after considering all of those reports and studies and testing that's referenced in ruling 4542, what did the state engineer do with application 4677?
He approved it. He permitted the application.
After having cited the very reports that we just discussed,
Yes,
having knowledge of what's contained in those reports,
presumably so.
staying with ruling 4542, council spent considerable time selecting portions of 4542 and reading them to you. I'm not going to read them all again to you. Judge has had them read to him several times. But I do want to just turn to a few of them. First one is page 1001. And this council read to you the entire paragraph 2. That paragraph there. If you can remember that, council read that entire paragraph to you. Talking about the Department of Wildlife, that they had protested the application, and on the grounds that the permit would not be in the best public interest. It would be detrimental to the impact in wildlife values of the Muddy River drainage, including the Mwapit dace, which is an endangered species. And as past studies have indicated, that Coyote Springs supplies a major portion of the groundwater recharging the Muddy Springs River, which lies in the Muddy Springs groundwater basin, down gradient of Coyote Springs. You remember he read that to you?
Yes.
With all of that in mind, with that knowledge that the state engineer had, what did the state engineer do with permit 46777?
He granted it.
Let's turn to another part that council highlighted for you. Page 4, please, Hunter. Let's go to the very top, about 1, 2, 3, 4 lines down. 1, 2, 3, 4, 5 lines down. Flush right is based. See where I'm at? Just that sentence, based. Council read some of it. I think you read the whole thing to you, but look at this part. Based on the underflow, it has been estimated that the perennial yield of the Coyote Springs groundwater basin is 18,000 acre feet. With that knowledge of the underflow flowing through Coyote Springs Basin, and with the estimate of the perennial yield, what did the state engineer do with application 46777?
He granted the permit.
And then if you go down on the same page, heading 4, 1, 2, 3, 4, 5, 6 lines down, flush right is the carbonate aquifer. Just highlight that if you would. The carbonate aquifer is part of a regional interbasin groundwater flow system identified as the White River flow system. And then the state engineer himself cites the Eakin report. With that knowledge of the Eakin report and that knowledge about the carbonate aquifer being part of the regional interbasin groundwater flow system, what did the state engineer do with permit 46777?
He granted the permit.
Continuing on, and the last two lines of page 4. Hunter, the last 2 lines of page 4 there, starting several. And then if you could just carry that over, there you go. And then with, this was red, several thousand feet of saturated carbonate rock aquifers are believed to lie under portions of this region. And carbonate rock aquifers also transmit a regional flow of water, in this case, to the Muddy River Springs area. And the state engineer cites Eakin. And he continues, the regional distribution of carbonate rocks has hydrologic significance because they transmit a flow of groundwater in regional groundwater systems beneath the topographic divides. And then he cites Rush. With that knowledge that he had about all of the science that's just been shown, I just read to you. What did the state engineer do with application 46777?
He granted a permit.
We can
Let's take
continue,
our afternoon recess now.
and we will. Thank you so much, Aaron.
Convene at 3:30.
Yep.
All right.
Be seated, please. We're back on the record. And you may resume.
Thank you, Your Honor.
The witness having retaken the stand.
Yes, thank you. Mr. Richards, we were talking about ruling 4542, and I was reading just a few of the portions of that order that council had read to you previously. We could continue this for every part of 4542 that was read to you, but let me just do one more with the conclusion. This would be on page 014, the conclusion that we've seen many times. I'm not going to read to you again the three conclusions and findings that the state engineer had to make before issuing the permits. But this paragraph below those findings, or excuse me, those conclusions, was in fact read to you. I'd just like to highlight the second sentence in that paragraph that council read to you. Quote, the state engineer concludes there is no evidence as to the exact quantity of water available for appropriation from the carbonate aquifer, but there is at least 18,000 AFA available in total quantity. And council had emphasized that there was no evidence as to exact quantity of water. And yet without evidence of the exact quantity of water available, what did the state engineer do with application 46777?
He issued a permit.
Thank you. Those are all the questions I have for you. Thank you.
All right, recross.
Yes, Ron, thank you. We could have 3078, which I think is same as the 4542, but a different number. So just briefly, sir, council asked me a series of questions about whether there was an assumption that the state engineer read the rush report and the econ report 64 and 66, and your answer was, I assume that he did. It's footnoted. I recall that testimony.
Yes.
And he talked about some of the findings and statements with respect to the water going underneath essentially the topographical divides, or that there was evidence indicating that that water would flow beneath the divides. You recall that testimony?
Do I recall?
The questions and answers you gave on direct examination.
Yes.
Okay. And he said that despite all of those studies and reports and findings, the state engineer nevertheless granted the permits. Recall that testimony, his questions and your answers?
I recall his questions, and he was reading specific passages out of this ruling.
Right, and ultimately after every question he would say, and nevertheless, what happened with the state engineer, you said, granted the application 4677. Do you recall that line of questioning, his questions and your answers?
Yes, I did.
Are you telling the court today that that permit was issued unconditionally to CSI, or first to Nevada Power and then to CSI, that there were no conditions attached to that approved application?
No.
You didn't talk about the conditions either in your report, direct examination, or again on redirect. But do you recall that there are in fact conditions to that permitted that issued permit?
Well, I'm not sure if the first part of your the statement that preceded your question. I'm not sure that that's accurate, because there were things in this ruling that I did put into my report.
I'm talking about the conditions, sir.
So am I.
You think you put the conditions in your report?
Well, I'd like to review my report, and I can.
Either way, whether you did or whether you didn't, it's not true to my question. But to be clear, I want you to tell the court what the conditions were that were imposed by the state engineer in approving the application for 46777.
Can we turn to the pages that show those conditions, please?
You don't remember what they are without seeing the documents?
I don't have them memorized.
Okay. Let's go to page 0017. Take a look at conditions 4 and 5 and tell the court what those conditions were, to the extent that you have an understanding as to those conditions that were imposed on the issued permit.
Number 4 describes a comprehensive monitoring plan. Did I say number 4? sorry. Number 4 describes the requirement for a comprehensive monitoring plan. Number 5 describes a requirement by Nevada Power Company to submit an annual report of monitoring results.
Do you agree, sir, that those conditions were imposed to make certain that the pumping of that water under that issued permit would not adversely impact the decreed rights or the endangered species?
It's not explicitly stated so, but I think I also answered your questions regarding these two conditions previously, and I indicated as a preliminary matter, monitoring plans and annual reports of monitoring results are not uncommon terms and conditions that are applied on a lot of permits that the state engineer issues. Having said that, I think in general, the monitoring plan and annual report that is described here in this specific application relates to protecting public interests and Muddy River Springs area.
The decreed rights, is that included within one of the reasons why the comprehensive monitoring plans were in place and required to be monitored, that is the protection of the decreed rights?
I think that's probably true, yeah.
Do you know one way or the other?
Well, it's not explicitly stated, but my presumption is that these monitoring plans and annual reports were intended to protect the decree rights of the Muddy River Springs and river system.
And the endangered species, correct?
Yes,
Okay, because that was some of the bases upon which, among others, Fish and Wildlife Services objected or protested to the application. Would you agree? Having read the document in its entirety?
I would agree.
Okay. And so you, to round out your testimony to the court, after considering all of the studies and reports that were footnoted in the various protests lodged by the interested parties, the state engineer approved those and then conditioned them on not impacting the decree rights and the MWAPA dates. Agreed?
Agreed.
Okay. And those conditions continued through today's date with respect to those permanent rights. Agreed?
Yes,
Okay.
I assume so.
And one of the things that we note with respect to the requirement of a monitoring plan was also the requirement that there be pumping that occurs, right? So that they could monitor the effect of that pumping. Agreed?
I don't think this ruling or this permit has terms that require pumping as part of the monitoring plan or the annual report that's described in these two sections 4 and 5.
So do you understand that they're going to be monitoring water that's not being pumped? Is that your testimony?
No.
Okay. If you go to 0010, please. Item number 0010, item number Roman numeral 10. Says the state engineer previously stated in the ruling under applications 55450 and 58269 that the only way to know whether or not long-term pumping of the carbonate aquifer at high diversion rates will affect the alluvial aquifer, springs, Muddy River, and water right holders is to allow pumping to occur and monitor the aquifers. Did I read that correctly, sir?
Yes.
Okay, so now do you understand that there was a requirement that there be some pumping to monitor, long-term pumping to monitor the effect on the right holders and in the down gradient basin?
Objection. The question misstates the document.
I asked if you understood it.
He can.
Misstates the document.
You can say so.
He can interpret.
Your Honor, I'd appreciate your ruling instead of council's ruling on my objections.
He gave it.
So did you.
We're saying the same thing.
I'm not going to argue with the council. I just want the court
Go
to
ahead.
respond to my objections.
He did.
Okay, I'm sorry. Can you repeat the question?
Sure. Does this refresh your recollection, or do you understand from having read that there was requirement to do long-term pumping to see if it impacted the rights in the Muddy River Springs area, which is downgraded based on 219?
This statement does not specifically require pumping. It indicates that the way to know whether pumping of the carbonate aquifer will have effect is through a pumping plan.
And monitoring the pumping going forward, agree?
Yes.
Okay, so if we go to 0016 under Roman numeral 8. Oh, by the way, that reference the two application numbers, and you understand, sir, that those two applications were approved pursuant to that ruling 4243, right?
What two application numbers are you referring
Sure,
to?
let's go back to 0010. Because in ruling under applications 55450 and 58269, those rulings were, or those applications were approved pursuant to ruling 4243 that I showed you on cross-examination. Do you recall that?
Yes.
And when you hadn't read that, even through today's date, 4243, and you don't know what the conditions imposed on the approval of those applications were. Would you agree with that, sir?
I would agree with that.
And at 0016, under Roman numeral 8, it says in the first, last full sentence from the MVWD hearing. Do you understand that to be the Muddy Valley Water District hearing?
Yes.
And that was the subject of the 4243 ruling, to your knowledge?
I'm sorry.
Sure.
I think it's the
slow
Moapa Valley Water District hearing.
You're right. Moapa Valley Water District hearing. And that's what was the topic of the subject of 4243. Agree?
I'm not certain about that.
Okay. Do you have any idea what it means when it references the MVWD hearing?
I'd have to have a look at some of the preceding sections of this ruling.
Okay. Whatever that hearing is, it says, and from other records at the state engineer concludes the following. We've been through 1 through 3, but just read into the record item number 4.
The way to determine impacts is to allow additional pumping of the carbonate aquifer and monitor the effects.
Okay. So you knew, at least from reviewing 4542, that the only way to determine whether there's going to be conflicts was to allow some long-term pumping. Agreed?
That's what this states. Yes.
Okay. And then there was the monitoring requirements we've seen in in items 4 and 5. We looked at a moment ago, right?
Yes.
And tell the court what the monitoring plans reflected, if you would, that were actually approved by the state engineer.
I did not review them.
And you hadn't reviewed the memorandum of agreement that was entered into by and between the parties that also required monitoring to protect the Moapa days, correct?
Correct.
And do you know, sir, whether those monitoring plans were ever implemented that were required pursuant to 4542?
I think you asked me that question previously. And I think my answer was, I assume that they were.
Okay. But you haven't seen any data reflecting those, the results of those monitoring programs?
I disagree with that.
You have seen the results of the monitoring programs from the monitoring plans that you haven't seen?
No, I've seen results of monitoring plans. I said I did not see the results of the monitoring plans that are referenced in this ruling 4542.
Okay. And you haven't seen the monitoring results from 1169, correct?
I have seen the results of the 1169 pump tests as they were described in order 1309 by the state engineer.
Sir, one of the things that council asked you on redirect was this portion of the deposition that I read to you, and you clarified that, I think you said it was fact specific with respect to the state engineer's obligation if they need to indemnify.
Is there a question there?
Yeah, do you recall that line of questioning?
I do recall it, but you misstated it.
Right, he read back the deposition portion. And I had asked you whether there was a requirement to indemnify or to reimburse costs and expenses, and you said it's fact specific, but generally no.
I did not say that.
What did you say?
I said it was case specific.
Case specific, okay. And when you mean case specific, you mean each individual case may be different?
That's what I meant.
In Nevada, in your 33 years of experience, have you ever seen the requirement by the state engineer to reimburse a permit holder for their costs and expenses incurred in attempting to establish beneficial use?
No.
How about in any state?
Objection, relevancy, Your Honor.
Fair point, was probably a question.
Overruled.
Well, then that relevancy objection would apply to the prior question as well, Your Honor. Irrelevant.
It's been asked and answered, Your Honor. I'm trying to just very briefly in your qualification, you were qualified as an expert in 2015. And how many times since 15 have you testified as an expert before the state engineer?
Since 2015.
I'm sorry, only in water rights. I know you had the other expertise as well.
It's in my resume.
Okay.
4 or 5 times. 4 times,
Okay.
perhaps.
You talked about the inequities of the state engineer's determinations and consolidation. Sir, do you understand that there remains a possibility that water would be available in in phase 2 that might support the master plan community?
Objection, calls for speculation, foundation.
Overruled.
Can you restate that question,
Sure.
please?
You said, as I understand your testimony, that it was inequitable and essentially 1309 took away Seaside's ability to move forward with their master plan community. Is that correct?
Yes.
Is there a possibility, now that you understand the scope and breadth of phase 2, that there may be a determination at that time that there is water available to support the master plan community?
Same objection, foundation, speculation.
You can state his understanding of what's happening.
There may be a availability of water at what time?
During the phase 2 proceedings, sir.
Oh, during phase 2 proceedings. That's a possibility.
Okay. One of the things that you said, and you spent some time talking about, how the state engineer could do a pump test specifically in basin 210 and determine whether or not pumping water out of that basin would or wouldn't impact the down gradient decreed rights of the Wapadace. Is that your testimony, sir?
No.
Okay. I think council asked you, are there ways to determine, correct me if I'm wrong, whether pumping out of basin 210 would impact the decreed rights or the Wapadace? Was that your understanding of this question in your answer?
Yes, I believe so.
Okay. And I think you said it can be done, it has been done. Is that fair?
I did not say it that way. I said a way to do it would be, a potential way to do it would be to simulate the type of pump tests that were conducted in the mid-90s as they were described in ruling 4542.
Are you suggesting to this court that there is a scientific basis upon which it can be determined that the pumping out of that basin would not conflict with the decreed right holders and the want days?
Can you repeat that, please?
Sure. Are you suggesting to this court that there's a scientific method to determine whether or not the pumping out of basin 210 would impact or conflict with the decreed rights and the endangered species?
I think there's possible ways that the determination could be made. I have not given a whole lot of consideration to how exactly what that exactly would look like, but I'm not going to say it's an impossibility necessarily. I just haven't given the time to be able to speak to the details of what those possibilities might be, how they might be implemented.
Didn't you say, sir, on redirect examination that it can be done, it's been done before, that there were pump tests done in advance with or in coordination with 4542 that demonstrated there could be long-term pumping?
Yes.
Actually mischaracterizes the witness's testimony.
If so, he can say so.
Was your answer yes?
Can you repeat the question, please?
Sure. Didn't you tell Mr. Hutchison on redirect examination that there is a method because it was done in coordination with or in support of the issuance of 4542?
That misrepresents my testimony.
Okay. What then, sir, were you referring to when you said 4542 was issued after pump tests had been completed?
That part is correct.
And you testified that the other pump tests were distantly related and closer to the decreed rights. Remember that testimony?
Yes,
And that those didn't reference or impact the decreed right holders or the multiple days. Was that your testimony?
my testimony was that this ruling 4542 provides all the details of those pump tests, the results of those pump tests, as explained in the state engineer's own words.
Yeah.
Yes, I know.
Okay. And you said after that pump test was completed, the state engineer had those results and made the determination that it would not, the appropriation of water out of basin 210 would not conflict with the existing rights. Agreed?
Agreed.
Okay. And is that the same sort of pump test that the state engineer, in your view, as a hydrologist, could be employed today to demonstrate to the state engineer that that water couldn't be appropriated without impacting the existing rights?
It's a potential way.
Okay.
There's a lot of details that goes into something like that. It's not just as easy as saying it could be done, it should be done. It's complicated, and just being able to create the controlled situation that would enable a determination as to whether or not there was any impact is very complicated.
Sure, but isn't it the same, and just so that I understand your testimony, was that a same complicated analysis when Wampa Valley Water District did it in connection with the applications that were then pending?
Yes,
Okay. And so that we know, I think your testimony is, and correct me if I'm wrong, that science exists that may be utilized to demonstrate to the state engineer that pumping water out of basin 210 will not conflict with the decreed rights in the Wampa days. Is that true?
yes.
Okay. Who, sir, did the pump test for Wampa Valley? Was that the state engineer or the permit holder?
I don't know.
Are you suggesting that the state engineer should be the one that does the pump test for CSI permitted rights?
No,
Who should do it?
I'm not prepared to answer that question.
Okay, but if you had read 4243, and I'm happy to show it to you, but the 4542, the document itself indicates that the pump test was done by Wampa Valley Water District. Do you know that?
Do I know that to be true?
Yes, sir.
I think it's in 4542. Those are the types of details that I continuously said are in the ruling itself. I don't recall that particular detail, but there's a good probability that that's in there.
Right. Wasn't it the permit holder that was seeking to convince, at least in 4542, seeking to convince the state engineer that water could be available without conflicting with the existing rights?
You know, this question's been asked in one form or another 3 times and answered
It hasn't
3
been
times.
asked once.
Your Honor, can I just get a ruling from the court instead of from council? This question has been asked and answered 3 times in different forms, but it's the same question over and over again. I think it's the point where council now is just harassing the witness.
You know, just because council says it doesn't make it true.
All right, overruled. Go ahead.
You understand my question, sir?
Yes,
Okay, and would you agree with me, sir, that it is the applicant that is seeking to demonstrate to the state engineer that it can appropriate water pursuant to an application and that the approval of that will not conflict with existing rights?
can you repeat that
I can
question,
try.
please?
Isn't it true from your review of not 4243, but the 4542? Don't you have the understanding that it is the applicant that was seeking to demonstrate to the state engineer that water could be pumped without conflicting with existing rights?
No.
Who was doing that?
Maybe we pull up ruling 4542.
Of course.
Is that it's necessary?
Okay.
I stated that that information or the answer you're seeking is probably in the ruling, and
Is it?
I'd rather not guess.
It's 3078. Yeah, he's not gonna be clear. The reference to 4542. Respect to the copy. Respect to the one. Fine. 3078. You can go to 005, please. And the last paragraph on 005, you could read that into the record, sir.
An aquifer test of the carbonate system was conducted by the Wampa Valley Water District, parentheses MVWD, in support of their water right applications 55450 and 58269.
Okay. Does that refresh your recollection as to who was doing that pump test?
Yes, thank you.
Okay. And do you understand, sir, that that pump test was done in an attempt to demonstrate to the state engineer that the water could be appropriated without conflict to existing rights?
I understand that that pump test was conducted in order to support Wampa Valley Water District's request for permits under these applications.
Okay. And do you know, sir, without having read 4243, but just from the content of 4542, it was in an effort to demonstrate that the use of the water wouldn't conflict with the existing rights?
Question was just asked and answered.
He didn't answer.
He just answered it.
I thought he did.
He did, Your Honor.
Next question.
Sure. Do you know, sir, whether or not then the pump test by Wampa Valley was considered by the state engineer in making a determination as to whether the pumping out of basin 210 would conflict with existing rights?
Basin 210 in general? Or
Connection with the application, sir?
in connection with application 46777, yes.
Okay. Now, based upon your understanding of the pump tests and the utility of those pump tests, isn't it true that CSI could come forward and demonstrate during the phase 2 proceeding, utilizing some pump tests that it employs, that its water may be used without conflict?
Objection. Lack of foundation, calls for speculation.
He state his understanding of the.
I didn't hear a portion of your question.
Sure.
Can you please repeat it?
Yeah, understanding what we just looked at in 4542 and the pump test that was presented by Wappa Valley Water District that was utilized by the state engineer in making a determination as to whether water would be appropriate without conflict. Isn't that something that CSI can do now?
It's an option.
And had they had that option for, let's say, 2018 forward?
You know, there's a lot of detail that goes into that, and it's not a simple answer. It's not a simple question, and I shouldn't have answered it as simply as I did. When you say, could they do that? There's a lot of planning and design and just a lot of time and resources alone would have to go into doing that. And so I can't speak for CSI and say that they can do that.
But it's an option. Agreed?
I can't speak for what CSI can do or cannot do.
Final question, sure. Is it true that the only thing that has been restricted is CSI's ability to obtain a subdivision map?
No,
Do you know that they have other, or do you know whether there are any alternative beneficial uses that water can be put to?
under their existing permit,
Yes, sir.
their existing permit specifies that the water shall be put to beneficial use for municipal purposes. If there are others, they would have to file a change application to change the manner or to request to change the manner of use. Under their current applications or permits, based on the rights that were so granted to them, their manner of use is specified as municipal and domestic.
You finished?
Yes, thank you.
And municipal domestic includes all the things that would fall under the municipal and domestic use definition. Would you agree with that?
Yes.
Not limited to subdivisions, agree?
Pardon?
Not limited to subdivisions or residential? If you know, sir.
It's a general municipal and domestic is a general
Okay, final
categorization of that particular beneficial use.
final serious questions, or maybe just one or two. 1309 did not change the source and supply of water in the super basins, did it?
Yes, it did.
Okay. It actually altered the source of the water within the various basins?
Well, in the context of how the state previously administered water rights on a basin by basin approach, and how the unprecedented super basin changed that historical management, I would say it did change things.
Finished?
Yes, thank you.
I understand that the management has been changed under your opinion. I'm just talking about the actual source and supply of the water, setting aside management issues, source and supply of water has, for those super basins, has been the same for time immemorial. Would you agree?
There's only one super basin.
For all of the basins, sub basins, if you will, in the super basin, the source and supply of that water has been the same from time immemorial, at least as far as we know. Agree?
No,
Did it change at some point?
yes,
When did it change?
it changed in May of 2025.
That's the management aspect of it.
Objection.
That's the source, that's the source and supply question that you're asking me about.
Just trying to finish this question so I can sit down and then Mr. Or council can ask you one more question or more. The source and supply of water relates to the carbonate aquifer, doesn't it?
Yes, it does.
That carbonate aquifer wasn't changed pursuant to 1309. Agreed?
Agreed.
Thank you, Mr. Richards.
No question, John.
Okay, sir, you stand down.
Thank you.
Continue.
It's been an honor to testify in this court.
Thank you.
Thank you. Forget here. I just call Bonnie Rinaldi, Your Honor.
You do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help God.
I do.
You may be seated. Can you please state your full name and spell it for the record?
Yes, my name is Bonnie Rinaldi.
Can you spell it, please?
Yes, Bonnie is Bonnie and Rinaldi is Rinaldi.
Thank you.
Was Mr. Sylvester going to be back?
I got it.
Okay.
Let us know once you're ready, Ms. Rinaldi.
I'm ready.
Get comfortable.
Thank you.
Ms. Rinaldi, are you familiar with a development project named Coyote Springs?
I am.
How so?
Well, I was retained by Coyote Springs Investments to provide expert witness, expert testimony, and expert report on whether or not they had complied with the requirements of a master plan community in Clark County.
And what are your areas of expertise?
My area of expertise is primarily in development and development processing.
And do you have any expertise in issues of land use or entitlements?
I do. I worked in the business of land use and entitlements in Clark County for, well, my career in Clark County was over 27 years, largely in planning and development and largely in entitlements with Clark County, also the city of North Las Vegas. And then I was assistant city manager with the city of Henderson. But
And let's talk a bit more about your background, experience, training in that area. Can you tell us, give us an overview of your educational background?
yes, I have a degree from Penn State University in what was called Man Environment Relations, and a division of that was in community planning
And when did you graduate?
in 1978.
And as we talk about your work experience, work history, is it easier for you to review your CV?
Sure.
Okay, can we pull up exhibit 554, please? And if we could, let's maybe start on the last page. Start there. So you graduated from Penn State, you said in 1978, correct?
I did.
And your first position after graduating from Penn State was where?
With the city of North Las Vegas.
And can you give us a general overview of your duties and responsibilities while with the city of North Las Vegas?
Yeah, I started there as a planning technician, reviewing permits and applications for development and working on comprehensive plans for the city. I moved into a position of urban planner with the city while I was there.
Okay, and during the time period, and maybe strike that, I'll start over again. How long were you with the city of North Las Vegas?
I was there for 6 years approximately.
And during that 6-year time span with the city of North Las Vegas, did you gain any experience in issues relating to land use?
Oh, absolutely. That was what I spent my entire time there on issues of land use.
Okay, did you have any experience or training in areas of entitlement matters?
Absolutely. That's what I worked on.
Okay, and the development of master plan communities?
There wasn't much in the way of master plan communities in the city of North Las Vegas or anywhere in Clark County at that point in time.
Okay, and when you left the city, left your employment with the city of North Las Vegas in 1984, where did you go next?
I went to Clark County and worked there as assistant zoning coordinator. And that was, that entire job was entitlements. It was processing the requests for any kind of land use entitlement, hundreds of them every month for a lot of years.
Would you say hundreds of them a month for many years?
Yes.
Okay, and you also had experience while with the county working with master plan communities?
I did. After my daughter was born, I was looking for something to cut back my time because in processing hundreds of applications every month, we had many long nights and very long weeks and 70 and 80-hour weeks on a regular basis. And there was an opportunity that the folks that are involved with Summerlin were interested in expanding and into Clark County's jurisdiction, as opposed to within the city of Las Vegas, where they had already been building for a number of years. Yet Clark County did not have any mechanism for reviewing a project of that scope. And so the management at the county asked me if I would consider developing that process and working with Summerlin to develop it. And then ultimately, I ended up also negotiating on behalf of the county, the development agreement for Summerlin.
And can you give us a time frame of when that started, the process of your involvement with the development of Summerlin?
Yes, 1993, and it ended in about 1996 when it became a full-time job and I moved into another position at county.
And just so we're clear, that was the beginning of the development of Summerlin here in Clark County?
Summerlin South, yes.
And you implemented the county's process of working with developers on master plan communities?
Yes, it was called major projects. And master plan communities were the type of major project that was considered then. So, you know, Summerlin was at least 5 miles outside of any service area, not service area, but outside of any utility line or road at that point in time. It had been purchased. The property had been purchased in the 50s. And now 40 years later, they were wanting to start some development there. And yet we were still 5 miles away in terms of any kind of water lines, sewer lines, roads. And so the question was, how do we do that? First, should we do it? Should the county do it? And then how? And so we needed to create a process for the county to consider that huge, comprehensive kind of development in a way that also worked for the developer. And so we created a step-by-step process for looking at projects of that magnitude.
And how long were you employed with Clark County?
I was employed with Clark County until 1999
And then where did you go next?
to the city of Henderson.
And what was your title with the city of Henderson?
I was assistant city manager there
And how long were you assistant city manager?
for about 5 years, almost 6.
And can you provide us an overview of your duties and responsibilities as assistant city manager with Henderson?
Yes, my role was to lead several different departments that were all development related, the planning department, public works department, parks and rec, and so forth. So I was in much more of a management role, not on the day-to-day processing or reviewing of development plans.
Okay. And when you left the city of Henderson, what was next for you?
What was next for me was I was approached by several property owners who collectively owned some acreage in the Moapa area. And there were 7 different owners, 7 properties, some of which were contiguous, some which weren't quite. And yet they recognized that the kind of a project of the magnitude they were envisioning out in Moapa, where there was essentially no development of that intensity at the time, would require a master plan community approach. And so they joined together, created Glendale Holding Company, and they hired me to lead the effort to gain the entitlements for that community.
And how long were you working as a consultant with that?
With that group was well over 10 years, started in 2005, and about 2007, the real estate market fell apart, and there was a decision made that those owners were going to have to hold their properties for a much longer term than they were anticipating previously. And so they dissolved Glendale Holding Company, and there was a lot of administrative work to sort all that out. And I continued to work for them for a few years to dissolve their holding group.
And during the time period where you've been working as a consultant, have you assisted any other master plan communities or proposed master plan communities?
Yes, I'd be brought in from time to time on a couple that Jim Rhodes was involved with. Some, there was 1 or 2 in Arizona, and I believe on the Blue Diamond Hill project before it had that name, but and maybe others, but he brought me in from time to time to participate with his development team.
And during the time period where you were employed with government entities, were you involved with any professional associations?
I was. When I was a planner, I was part of the American Planning Association. I was a certified planner under the American Institute of Certified Planners. And there may have been another 1 or 2, and then once I wasn't working as a professional planner anymore, I was involved with the City Management Association.
And have you authored any articles regarding land use or entitlements or master plan communities?
Oh, to some extent. An article that I was requested to write had to do with the city of Henderson and their approach with master plan communities, and so it was more general about the city of Henderson and how it dealt with master plan communities, some of its history.
And have you done any prior work as an expert witness for purposes of litigation?
I've been hired before to provide expert reports. The litigation never proceeded to court.
And the document in front of you, Exhibit 554, is this a true and accurate copy of your current CV?
It is.
Move to admit 554, Your Honor.
Objection. Admitted.
And Mr. Rinaldi, Exhibit 554, does this fairly and accurately summarize your work history and your experience with master plan communities, entitlements, and land use issues?
I think so.
What was the practice of community planning like when you first began your career in the 1970s?
It was interesting. This was much more of a cowboy kind of town. Development really happened willy-nilly, one piece of property at a time. And each was reviewed on its own merits. They were all relatively small developments. Over time, though, we had some commissioners that had a lot of foresight, and they started to consider that we needed a bigger framework because they had grand plans for Clark County in particular. And so they started to hire some professional planners that brought some concepts to town. I was still at the city of North Las Vegas at the time, but brought concepts to town about looking at things comprehensively. They started, for instance, the airport environs program where they were protecting the airport, putting regulations in place that had to do with sound and where things could be built based on the amount of sound that would be coming from the airports, because they wanted to protect airport operations because it was so critical to our community to be able to continue the full utilization of the airport. And then they started to go beyond that to, how do we look at this entire community? How do we think about its water? How do we think about its sewer? How do we approach? Instead of just taking one development at a time, do we develop a comprehensive plan about what neighborhoods should look like and what special attention maybe should be given to the strip versus outlying areas? How should we consider outlying areas where we don't have utilities? Should we even consider them, or should we wait until the utilities are there and then say, okay, now you can develop your property because we know that you have a water line, a sewer line, you have streets, so we can accommodate your development.
And you mentioned a few minutes ago, the Summerlin Master Plan Community really started to gain some traction, and I think you said 1993, fair? So by 1993, was the Las Vegas or Clark County in general a bit more aware as far as long-term planning and getting the county getting involved with master plan communities and developments?
It certainly was, and a big issue at the time became one of the newer constraining issues that people were becoming aware of was water. And so I believe, frankly, that the reason that Summerlin wanted to develop part of their community in Clark County and part of the community in the city of Las Vegas, instead of just continuing with the city of Las Vegas where they knew the procedures and the rules and the people and, had that kind of down pat already. It was because at that point in time, we began to manage water. And one of the first steps in managing the water was to take all the water that was available to this valley and divvy it up amongst the various purveyors. The city of North Las Vegas had a pot of water. City of Las Vegas had a pot of water. Clark County had a pot of water. City of Henderson had a pot of water. And they could continue to approve development within the amount of water that they were assigned to have. And I believe that Summerlin wanted to have their hands in both the city of Las Vegas pot of water and Clark County's pot of water. Now, the management practices changed after the Southern Nevada Water Authority came on board. The community learned that looking at this one community at a time was not going to be successful in the long run. It was a first step in how to manage water and not over allocate, so to speak. Although those words have very different meanings when you're talking about the state engineer and their processes. But the first step was to make sure that there was no development that was approved that we didn't already have water rights, not water rights, but water for. And so, but then we stepped back to take a longer term view and realized that even those pots of water that we had at that point in time wasn't going to be enough for what everybody envisioned Las Vegas could be. At that point in time, our community was about 700,000 people, and we were at that point in 1993 or 4 seeing the end of growth to Las Vegas because of our limited amount of water that was currently existing. But as you can see through a lot of water management, we've now quadrupled that number of people and still have water. We're still growing.
And you were directly involved with the the development in Summerlin, fair?
I was,
And you said you negotiated the development agreement?
I did.
Okay, can you tell us about that process? Actually, let me start over. Prior to that development agreement with Summerlin, were development agreements common within Clark County in your work experience? Have you
No,
seen
they
them?
did not exist. They did not exist. They may have existed as a tool within the state planning laws, but it was not a tool that was used by Clark County. And that was my first assignment relative to Summerlin, was to along with the other county staff and with input from the developer, create a system of review that would be effective for both the developer as well as the county.
A lot of paperwork involved, I'm assuming?
A lot of paperwork, a lot of meetings, a lot of consultation with the developer, a lot of consultation with every department within the county about what was needed, how to approach a project of this size. Quite a big concern on the part of the county was, well, Bonnie, how can I all of a sudden just turn around and dedicate 10 hours out of every week to one project when the commissioners have me working on 16 other projects? And so we had to devise a way that gave direction to staff, gave direction and some assurance to the developer that this was something that was that the county wanted to do.
And during the course of your career within Clark County, including North Las Vegas and Henderson, are you familiar with the various steps or processes that a developer must go through on a master plan community?
Well, I was the lead author on creating those steps within Clark County.
Are you familiar with the interactions or processes a developer has to go through with the various state agencies on a master plan community?
The state agencies? Yes, I have some familiarity. As a planner, your job is not only to represent your department in reviewing a proposal. You're not only looking at, is the zoning right? Do they have the right size lots? Do they have landscaping in the right place and the right number of parking spaces? But you also have a big job in coordinating, because you're the one who presents it to the planning commission and the city council or county commission. You have a big role in coordinating every other department's comments, and those departments and agencies included the State Department of Transportation, State Division of Water Resources, Division of Environmental Protection, the Health District. Many agencies got involved with projects, and you had to have an understanding of the processes within each of those agencies to understand that, have a context for their comments, and know how to package them and appropriately present them to the Board of County Commissioners, because you were the only mouthpiece on behalf of all those groups for the county of Kissimmee.
And during the course of your career, you became familiar with the various documents, filings, and steps that a developer must take on a master plan community relating to the county, working with the county?
Oh, absolutely.
Okay. Your Honor, we'd move to qualify Ms. Rinaldi as an expert on issues of land use, entitlement matters, and the process and procedures related to the development of master plan communities in Clark County.
I don't think that you need to recognize her as an expert or to be able to testify.
Sorry, say that.
I don't think that you need to recognize her as an expert for her to testify as an expert. I think that qualification requirement or proffering is long, not the law in Nevada anymore. But so I just object to you recognizing a witness as an expert.
It should be so deemed.
Thank you, Your Honor. Ms. Rinaldi, you mentioned that you prepared a report for this litigation, correct?
I did.
Okay, in addition to your experience and training and background, what types of information did you rely upon in preparing that report?
Well, from my experience, I knew to look at the details. And so I looked at all of the applications. I went to the county's public record on their website and looked at all of the applications that were filed in the Coyote Springs area and reviewed large and small things like their concept plan, their specific plan, their public facility needs assessment, their development agreement, looked at every use permit, every variance, every waiver, every subdivision map.
And those materials on the Clark County website are reliable? That's something you relied upon back when you were working for the county?
Didn't exist when I worked for the county, but they are reliable.
Okay. And did you reach any opinions in this case regarding Coyote Springs?
I reached 3 opinions.
Okay, let's just briefly summarize those and then we'll talk about them further. What was your first opinion?
Okay. My first opinion was that Coyote Springs took all the steps to get proper approvals for the Coyote Springs project. That process for them was particularly complex and particularly long because there was so much involved. The size of their project, the scope of their project, the fact that it's located remote from the Las Vegas Valley, and the order of magnitude of the commitments they had to make or they agreed to make in order to bring this community into fruition was beyond that of any other master plan community I'm aware of, certainly in the greater Clark County area, is one of the largest in the country.
And what was your second opinion?
My second opinion was that 2 subdivision maps, one for 8 builder lots and one for the tentative map was for 575 single family lots. And the final map that was submitted for that, I'll have to get back, explain sometime about how tentative maps and final maps differ, but the final map for that was only 30 lots. So the 8 builder lots and the final map for 30 lots met all the requirements of the county code and state statutes and should have been approved by the state engineer.
And your third opinion?
Third opinion was that the map for 8 builders lots should certainly have been approved because it didn't require any greater appropriation of water. The water had already been committed to that particular land area. They were simply re-subdividing a map that they had, several maps, 2 maps that they had previously recorded. They were re-subdividing, and the water that had been allocated to those 2 previous maps was there for reuse and to be re-subdivided and reassigned to those 8 builder lots and should have been done. Required no will serve letter, no commitment from any water purveyor, because we were talking about very large lots that the state engineer makes the water commitment of basically 2 acre feet per lot.
If I understand you correctly on your third opinion, your opinion is that the large lot map should have been approved because it had been previously approved.
Because the water for it had previously been allocated to that same exact land.
That amount of water, actually more water for that same lot had previously been approved?
Yes.
Okay. Let's step back a little bit and talk about master plan communities and how they're created. If you can give us an overview of that process.
Yeah, in Clark County, well, first of all, master plan communities are very comprehensive. They include residential uses, commercial uses, high-rise uses. Some, in the case of our area, they include resort uses often. And there's a lot involved. They have to develop schools, parks, police stations, fire stations, lots and lots of considerations beyond the typical just water lines, sewer lines, roads that most 10-acre housing projects have to do. And so in Clark County, it starts with a concept plan. It starts with a relatively limited investment on the part of the developer, but also a relatively limited investment on the part of the county to propose a concept, give us a general description of what you want to do and the scope of it. And the county will provide you with feedback about what kind of issues they see, what the concerns are, what areas need to be addressed. So at that point, The county is making a commitment only to further pursue this, but it gives all the staff the green light that yes, the administration of the county, the management of the county thinks this is a priority, thinks it could be a worthwhile project and would like to explore it further. And it allows everybody from each individual department to the town boards and each county commissioner to express what their intentions are or what their expectations are, what issues need to be further explored and addressed. So the developer gets a lot of feedback based on a concept plan that usually does not require very much investment on their part. They don't have to design the water lines. They don't have to tell us exactly how many units they can fit on their property. They express their vision and the county reacts and gives feedback on that vision. Once that step has been completed, the next step is to basically prepare what amounts to a master plan for that area. They lay out their land use proposals, you know, where the houses would go, where the hospitals would go, where the shopping centers would go, and lay out how many trips, commercial trips, how many residential trips. You get some order of magnitude of how many cars we're talking about, what size roads we need, what size water lines and sewer lines we need. And they start looking at what kind of public facilities are needed to support that. How many schools do we need? How many fire stations do we need? How are we going to provide police service? How is the water going to be supplied to this property? How is the wastewater going to be managed for this property? So the developer has two different documents. One's called a specific plan that lays out the land uses and their design intention. You know, are they talking about a community with lots of with a golf course? Are they talking about a community with lots of landscaping? Are they talking about a lot of high rises? You know, what's the nature of this community? And that's in the specific plan. And then in the public,
That would be the second phase?
these are
Concept
two
plans.
parts of the second phase, yes.
Okay.
And the other part of that second phase is that assessment of what kind of public facilities are required to support that land use as proposed.
And that second phase then, larger investment?
Much larger investment. They don't have to do the ultimate traffic study, but they do more generalized traffic study, more generalized flood control studies, more generalized studies about how much wastewater is going to be generated and what kind of fire service is needed. And they develop those studies and they meet with each of the various agencies and departments where they get feedback and they get to the point of concurrence. And when they get to the point of concurrence where they've got a plan that the county staff can endorse, then it's presented to the county commission. And then the developer walks out of that step of the process knowing that, okay, I think the county is saying we can develop 50,000 residential units here. We can do a high rise of up to 10 stories generally. We can expect to have to build 5 schools, 1 fire station. They have the general expectations of what is required. And then they can determine whether they're ready, then want to go to that next step but they have that assurance that it's been scoped out and the county has agreed that if you build this is what we're going to ask you to do to support it.
Sort of a step-by-step process for both the developer and government?
It very much is, and it's broken down into these steps, basically to manage risk on everybody's part. You can't walk in with a full community, basically a small city, designed down to the degree that we can let you build it the next day, all in one chunk. We have to take it in steps so that the developer has a good idea of what order of magnitude the county is going to support, what order of magnitude the county is going to request in terms of public facilities to support that development. And so with those assurances, they move on to then the next step. And the next step is a development agreement where we take that plan And that public facilities needs assessment, and we converted it into a legal document that says, okay, you're gonna be able to do this many units and this kind of a plan, as long as you agree to build all these things in this kind of manner. Like there may be triggers set up, like after your, you know, after the home number 300, you're gonna have to do this, and after home number 1,000, you're gonna have to do that. That all those triggers are then set up forth in a development agreement. Another very important thing is development agreements lock in the codes. Master plan communities take a long time to build. Things change, and county commissioners change, and community expectations might even change. And so, but the developer can't start investing to that degree of magnitude without some assurance that the rules aren't going to change on them. And so they lock in the codes, the county code that exists at that point in time. And so even if the county code changes, they're not subject to the changes, they're subject to the code at the time of the development agreement.
All right, council will adjourn now and we reconvene tomorrow at 1:15.
Thank you, Art.
1:15.
1:15.
1:15.
Got it.
Thank you, Your Honor.
And that'll wrap it up for the day. Thank you so much for tuning in to W4Nevada Live's continuing coverage, day 13, where we come back tomorrow, day 14, half day at 1:15 p.m. for our continuing coverage of Coyote Springs LLC versus the state of Nevada. And remember, as always, we're not just Vegas.
We're not just Vegas, you're not. Read the whole map, read it. Lights don't run the state, no they don't. That's a small cap, small cap. We're not just Vegas, look around. Past the neon haze, past it. 17 counties, all of them. Different lives, same place, same soil, same soil. They think Nevada starting in on the strip. That's like judging a book off the cover it get. Vegas loud, yeah, but that's just a slice. Plenty state left once you drive past the lights. There's towns where a handshake still means something. Where folks know the land and the seasons are blunting. Where work don't trend and patience is learned. Where votes still matter cause people return. We don't all gamble, we don't all party. Some folks wake early, boots, dusty coffee. Some places quiet, some places spread. Some rows long conversations with your head. The state breathe wide, not stacked in a frame. Don't shrink us down to a postcard name. We're not just Vegas, no way, no way. That service talk, surface, surface. Real Nevada, out here, outside the wall, outside, outside. This land where the sky feel heavy or blue. Where the silence louder than the news. Places built slow, no rush to impress. Where people still show up, not just express. Some counties keep food on shelves you don't see. Some keep water managed responsibly. Some keep the lights on, roads still paved. Some keep the history from getting erased. Not every voice come with billboards and sound. Some carry weight just by sticking around. We don't move fast, cause we plan ahead. We don't burn bridges just to feel sad. Nevada ain't one tempo, one look, one lane. It's contrast stitched into the same terrain. We're not just Vegas, past the glare, past it, past it. The state move quiet, steady, everywhere, everywhere, all around, all around. If you move here, welcome, just learn the pace. Respect the ground, don't rush the place. We don't copy cities that couldn't hold. We're not just Vegas, yeah, nah, yeah, no. Read the whole map, read it, read it. Lights don't run the state, no they don't, no they don't. That's a small cap, small cap. No, we're not just Vegas, look around, look around. The neon haze, past it, past 17 counties, all of them. Different lives, same place, same soil, same soil, same soil.